Something just happened in the world of gun rights that almost nobody is prepared for. A unanimous federal court decision dropped without warning. The Department of Justice instantly contradicted itself, and the future of the Second Amendment may now be heading in a direction most gun owners never expected. What began as a simple suppressor case in Louisiana has exploded into a national constitutional fight, one that could reshape how every firearm in America is regulated. And the craziest part, the DOJ openly admitted that suppressors are constitutionally protected arms, and then immediately used that admission to argue for keeping suppressor restrictions in place. It's a plot twist so bizarre that even legal scholars are stunned. But as you're about to see, this isn't just a suppressor case. This ruling could become the blueprint the government uses to expand NFA-style regulation to everything: rifles, pistols, magazines, anything they can classify as requiring a permit. So let's break down exactly what happened, why it matters, and how one man's solvent trap turned into a legal battle that could redefine the Second Amendment for decades. It all started with a shocking reversal inside the Department of Justice. For decades, the DOJ argued that suppressors were not arms protected by the Second Amendment. They used that position to defend the National Firearms Act, claiming that because suppressors aren't weapons, the government can regulate them without constitutional scrutiny. That argument helped the government win case after case. But suddenly, everything changed. In a brief submitted to the Fifth Circuit Court of Appeals, the DOJ admitted, clearly, directly, and without hedging, that suppressors are constitutionally protected arms. This was a total reversal of their long-standing position. But here's the twist. Even after acknowledging suppressors fall under the Second Amendment, the DOJ insisted the National Firearms Act is still completely constitutional because, according to them, it operates like a shall-issue permit system. They essentially said, yes, suppressors are protected, and we can still regulate them however we want. This argument wasn't just a change in tone, it was a deliberate shift in strategy. The government sees the writing on the wall after the Supreme Court's Bruin decision. They know they can't keep arguing suppressors fall outside the Second Amendment, so instead, they've pivoted to a far more dangerous strategy, reframing regulations not as restrictions, but as permits. And that single word, permit, is now becoming the center of the entire fight. Because right after the DOJ submitted its new position, a 3-judge panel at the Fifth Circuit issued a unanimous ruling, and the consequences are enormous. The court upheld the NFA suppressor restrictions, not by saying suppressors aren't arms, but by agreeing with the DOJ's new logic. They said that because a person can technically obtain a suppressor by paying the tax, submitting fingerprints, passing a background check, and waiting months or even a year for approval, the burden is modest and therefore constitutional. Think about that. A $200 tax, extensive biometric collection, a federal database entry, and a wait that can be 6 to 12 months is now being described as a modest regulatory burden. The court even compared the suppressor process to concealed carry permits, saying the Supreme Court in Bruin suggested such systems are acceptable, but that comparison ignores something huge. Carry permits typically cost under $100 and take 2 to 6 weeks. NFA approvals can cost hundreds of dollars and delay ownership for nearly a year. If the government can call that a modest burden, then nothing stops them from applying the same system to any gun you own. And that's why this case is so dangerous. To understand how we got here, we need to talk about the Peterson case, the spark that ignited this firestorm. Kenneth Peterson ran a small home-based FFL in Louisiana. In 2022, 50 law enforcement officers, ATF agents, and local police raided his home. The search warrant cited vague concerns about record keeping and firearm traces. But out of everything they seized, the one item that led to federal charges was a single solvent trap locked inside Peterson's bedroom safe. Solvent traps are sold as cleaning devices. Many gun owners have them. But the ATF has increasingly been treating them as suppressors, even when they're unmodified, and that's exactly what they did here. They classified Peterson's solvent trap as a suppressor requiring registration, a tax stamp, and NFA compliance. Peterson had none of that, so they charged him with possession of an unregistered suppressor. His attorneys argued that the NFA suppressor requirements violate the Second Amendment. The lower court rejected that argument immediately, and that's what led to the appeal now shaking the country. The DOJ's entire plan hinges on convincing courts that the National Firearms Act functions as a permit system. If the courts accept that framing, the government gains the power to regulate any weapon through registration, taxation, and lengthy delays, all while claiming the regulation is constitutional because it's shall issue. That's the opening they're trying to create. And incredibly, the Fifth Circuit panel bought it. But there's a bigger problem underneath all this. The way the Fifth Circuit applied the Bruen decision is raising alarm among Second Amendment experts nationwide. In Bruen, the Supreme Court established that modern gun laws must fit within historical tradition. Justice Kavanaugh wrote a concurring opinion stating that shall issue permit systems for concealed carry might be acceptable if they use objective criteria and don't give officials discretion. The Fifth Circuit stretched that single paragraph far, beyond its intended scope. They used it to justify a tax and registration system created in 1934, decades before modern concealed carry permits even existed. They ignored that Bruen was specifically about public carry, not about mandatory registration of firearms or accessories. They overlooked the fact that suppressors aren't dangerous and unusual weapons, but common tools that make firearms hearing safe. And they disregarded that the original purpose of the $200 tax in 1934 was to effectively ban suppressors. Because $200 back then is equivalent to more than $4,500 today. Nothing about the NFA resembles a fair permit process. It was designed to suppress ownership entirely. And yet the Fifth Circuit treated it like a simple licensing requirement. What makes this even more concerning is that the court insisted their ruling wouldn't allow the government to impose the same requirements on all firearms, but they didn't give any limiting principle explaining why not. If the courts say the NFA's structure is constitutional because it's a permit, what stops Congress from adding your AR-15s, your handguns, or even magazines to that same system? Nothing. Absolutely nothing. That's why Peterson's legal team immediately requested an en banc rehearing. That means they are asking the entire Fifth Circuit, not just 3 judges, to reconsider this case. They argue that the panel misunderstood how the NFA works and misapplied the Supreme Court's guidance. They also warn that the ruling creates a deeply dangerous precedent that other courts will copy. But here comes the next twist. The DOJ, even after admitting suppressors are protected arms, has now filed a response urging the full Fifth Circuit to deny the en banc request. They want the unanimous panel decision to stand. They want this precedent in place. They want courts to accept the argument that registration, biometric collection, taxation, and year-long delays are constitutional as long as the government calls it a permit. If the full court denies the rehearing, Peterson's only option will be the Supreme Court. And this is where things get unpredictable. The Supreme Court has recently upheld certain gun restrictions, like in the Rahimi case, suggesting a shifting environment. But at the same time, the issues in Peterson are far more fundamental. They deal with the boundaries of federal regulatory power, the meaning of Bruin, and the historical limits of the Second Amendment. Several circuits already disagree about how to interpret Bruin. That kind of conflict often forces the Supreme Court to step in, and suppressors are widely owned, widely used, and widely considered safety devices. That increases the chances the court might review the case, but if they do review it, there's no guarantee they'll rule in favor of Peterson. And that uncertainty has millions of gun owners on edge, because if this logic stands, if courts accept that the government can impose taxes, registrations, and year-long delays simply by calling something a permit, then the entire structure of Second Amendment protection changes overnight. The government no longer needs to ban anything. They can regulate rights out of existence slowly, quietly, and legally. It could begin with suppressors, then move to SBRs, then magazines, then semi-automatic rifles, then handguns. Each one placed behind the same barrier: a tax, a registration system, a background check, and a year-long wait. Not banned, just delayed, just taxed, just regulated into irrelevance. And that's why this case matters so much. It isn't about one man in Louisiana. It isn't about one solvent trap. It's about the future of an amendment that doesn't say the right to keep and bear arms shall not be infringed unless there's a permit system. So if you care about where this goes next, stay alert. The en banc decision could come any day. And when it does, the consequences will ripple through every gun owner in the country. Make sure you're subscribed. When the ruling drops, you need to hear it before it becomes the next national shock.